It's a bundle that starts from page 190 up to page 286.
What is the page number?
Page 271. It contains an internal memo from Namcor.
You can proceed.
Now, Mr. Inamba, I'd just like to read for you in order for you to comment. This is an internal memorandum with which appears to come from Namcor as it appears, and it's dated 8 July 2022, and it's addressed to Mr. Immanuel Mulunga, the Managing Director, and it's from Olivia Dunaiski, the Commercial Manager, and subject there from the document is request to take over Enercon Namibia's assets. And I'll just read it to you, and I'll ask you to comment later. Purpose of this submission, it reads, the objective of this submission is to request approval for Namcor Petroleum Trading and Distribution to take over the current Enercon Namibia assets. Background: Enercon Namibia is a Namcor customer since November 2021. Enercon Namibia currently has an agreement with the Namibia Defence Force to supply them with petroleum products till 2031. They have been supplying the Ministry of Defence with petroleum products since 2014, and part of the agreement was to ensure relevant infrastructures are in place to fulfill their obligation towards the contract. Currently, Enercon's account has not been paid up due to non-payment from the Ministry of Defence. Enercon Namibia has then agreed that Namcor take over their assets to cover their debt, whereby 25 million will be allocated to the current Enercon debt. On page 272, additionally, Namcor would like to become the preferred supplier to the Ministry of Defence in the long run, and through acquiring these assets, it will put Namcor in a favorable position for future business relations with the Ministry of Defence. I will not read it in entirety. I think our council has the document. I just want you to comment in relation to the averments that Ms. Dunaiski says in the affidavit of her involvement. In other words, she says her involvement was little, if I can put it at that, and then the case against her is weak. What will your comment, if you have regard to the document I've just read to you, dated 8 July 2022?
The beauty of that affidavit, Your Worship, is that it doesn't allow for my colleague to paraphrase. It is there. Let my colleague just take the witness to that part where my client says her involvement was little, read it to the witness, and the witness can then comment, Your Worship. But you will no doubt appreciate, and I'm going to challenge my colleague to show me in that affidavit where my client says her involvement was little.
I'll start firstly on paragraph 21, where, before I get to the other aspects.
Exhibit, can I have exhibit F to G? That is the choose. You are starting at paragraph
21. It's on page 7 of the affidavit. Now, Mr. Inamba, I just want you to comment if you can. I'm interested in paragraph 21, and I'll read from where it says, the state believes that they have a strong case against me. I do wish to highlight, as has already been demonstrated, by my other co-applicant that the state's case is a weak one. Let's start there when you have regard to that memorandum there.
Your Worship, yesterday my learned friend already canvassed paragraph 21 with the witness, and the witness commented.
Counsel?
But it's in relation to the document. I'm trying to put context to the document. Yes, I did that, but it's in relation to the document. And I'll get to that. In fact, there is also paragraph 24, but...
Can you then just get to the point? Because
Okay.
this aspect was, just
All right.
get to the point.
Okay.
Yes.
So on paragraph 22.4, it says, I'm unaware of any sale of 9 service stations. As far as I'm aware, there was an asset purchase agreement concluded between Namcor Trading concerning the rights, interest, and title to the assets owned by Namcor.
It's owned by Enercon, not Namcor.
Enercon, yes. Do you have a comment, Mr. Nyambali?
Yes, I do. I believe the document supports that. Firstly, Your Worship, the state has brought charges of conspiracy. It goes to show that there were negotiations where Enercon had agreed to sell the assets to Namcor. The document was the origin, or rather was the document which resulted into the contract, or rather the offer, that was the commercial offer that was made to Namcor. And there is a description as to what is it Namcor was intending to buy, rather Namcor Trading was intending to buy from Enercon. And the rationalization as to why that was the case was provided. And the document is authored, or rather originated from Ms. Dunaiski.
And also still in relation to this document, the document that appears on 271 of Mr. Namanji's bundle, the internal memorandum, I just want to refer you to a paragraph here on that appears on page 8 of her affidavit, 22.5. We make reference to the internal memorandum, and I'll read it to you. I have not ever conspired with any of my co-accused and or anybody else for that matter to commit any offense, nor...
Also, similarly, Your Worship, yesterday, this paragraph was covered with this witness. He gave his comment. In fact, Your Worship, you will remember that yesterday I complained about the fact that the state is evading context in not covering 2.4 and simply jumping to 2.5, Your Worship. So that also has been covered, and it amounts to an unnecessary waste of time.
Counsel, any response?
Your Chief, I think that was in general yesterday. That's why I actually laid the basis. I referred this witness to the document on 271, and I'm inviting him to comment in context with this document here, not in general as I was doing yesterday. That's what I'm doing. That's why I'm doing that. So it should not be misconstrued to say, yes, I did that yesterday. It's true, I did it, but what I'm saying is that there is a document that I'm inviting this witness to comment on before I move on. So I do not see that I'm wasting time here. I'm trying to lay a basis of my question.
Your Worship, in all fairness, the document is here. The witness has, in fact, my colleague has read the document to the witness. My colleague should simply just get to the point, Your Worship. We shouldn't be wasting time on issues that have been covered.
Yes, Counsel, I'm in agreement with Mr. Kasper. Can you just get to the point? You have yes, let's just get to the point.
In relation to the asset purchase agreement, when we have regard to this internal memorandum of 8 July 2022, if one was to argue that Ms. Dunaiski's involvement was little, what will your comment be?
Your Worship, as far as in evidence established, Ms. Dunaiski was the one who received the evaluation report, and the evaluation report was attached to the memorandum, which was subsequently drafted for the attention of Mr. Mulunga, meaning she initiated the process as far as the offer was concerned, which culminated into entering into the contract. The amount was suggested in that very specific document, the amount of 53,212,000.
I'll pack that affidavit of Ms. Dunaiski. I just want us to move to exhibit D2. It starts at page 1 up to, it's Mr. Namange's bamboo. It goes up to page 189.
What page?
Of interest, page 150.
I don't know why we are conducting court with closed doors, but that door should at least be open.
It's an open court.
Yes.
Officers, can we have the door open? It's an open court. At all times, the doors must be open. Yes, we can proceed.
At page 150, paragraph 5.5. And I'll read to you. It says, the parties shall agree on specific project implementation plan or plans and budgetary allocations with respect to the establishment of MOD SPR facility and attach same hereto as addendum. It shall be competent for the parties to agree on the construction of additional MOD home-based fuel stations and or SPR facility, provided that installation shall be done at the cost of MOD. You get that?
I do.
Okay, so now there was evidence led in this court to the effect that Enercon actually spent money or used their own money, if I can use the right words that were used their own money to construct these home-based fuel stations. What is your comment, if you have regard to what I've just read to you now?
Your Worship, as far as my understanding is concerned, the installation was funded or it was done at the cost of the Ministry of Defense. In fact, Your Worship, when we looked at that documentations during the investigation, rather than agreement between MOD and Enercon, that specific agreement refers to MOD home base station, Your Worship, in a sense that there is no way it says those specific assets belongs to Enercon. It continuously say MOD home base stations, Your Worship.
And from your investigations, of course, at the Ministry of Defense, because the home-based fuel stations are the subject matter of this case, what did you uncover from the Ministry of Defense? What was their response? Whose assets were these, the home-based fuel stations?
Your Worship, the home-based station belonged to the Ministry of Defense. They did have, I believe that contract, Your Worship, there is specification as to what services Enercon was rendering for the Ministry of Defense, more so the supply of fuel, the management system on the fuel issues, and so forth and so on, Your Worship. But as far as the ownership is concerned, Your Worship, it was for MOD.
I just want also to invite your comment on a paragraph that I'll read to you, paragraph 5.7.2, still on page 150, and I'll read it to you. MOD shall be obliged to pay for the assessment reports produced in respect of the decommissioning processes and remediation works referred to under the provisions of Article 5.8 herein within a period of 30 days from the date of presentation of invoice by Enercon. All MOD home-based fuel stations which are obsolete shall be decommissioned by Enercon. Of interest, listen to the following. Any fuel dispensing or storage facility to which additions and or changes are required by MOD shall be carried out by Enercon at MOD's cost. What is your comment with regard to that?
Your Worship, the ministry was carrying the cost. Enercon was a service provider as far as the services that were listed are concerned, Your Worship. And Enercon would invoice the ministry to which the payment would be made in that regard for the services that were rendered.
All right. Now, thank you. I just want to move on now to the affidavit of the seventh applicant, Mr. Leo Stephanas Nandaho. It's exhibit, Your Worship, is exhibit G.
Yes.
Your Worship, of interest, I'm at page, unfortunately, okay, it's not numbered, but I'm starting at paragraph 62 of that affidavit. 62.
Yes.
And I just want to read to you what is said there so that you can comment if you have any comment. Therefore, it is evident that the state also in this charge of fraud as couched in count 61 and its alternative charge does not have a strong case against me, not even to mention accused 15, Irongo Petroleum. Before you answer, I just want to read to you count 61. And I'll read it to you. That is count 61. It's a fraud charge against the seventh applicant, Leon Stephanas Nandaho. It reads as follows. Whereas the accused did between December 2022 and May 2023 at or near Windhoek in the district of Windhoek, there should have been the accused.
It says they did, Your Worship. My colleague must not paraphrase the charges. He must read it as it appears there.
Did wrongfully, unlawfully, falsely, with intent to defraud, give out and pretend to Namcor that fuel to the value of 238 million, which Namcor had supplied to Irongo Petroleum CC, had actually been paid for, and did then and there by means of the said misrepresentation induce Namcor to act to its own actual prejudice by supplying fuel to Irongo Petroleum CC in the amount of 238 million. And as a result of the said misrepresentation, Namcor suffered an actual loss of 238 million, whereas in truth and in fact the accused, when he received the fuel and pretended as aforesaid, well knew that his representation was fraudulent, and thus the accused did commit the crime of fraud. Now, when you have regard to what I read here in the affidavit, which actually says the state does not have a strong case against me. What is your comment with regard to that?
Your Worship, evidence established that at the time in question, Mr. Nando was 100%, held 100% interest of Erongo Petroleum CC. Erongo Petroleum CC had, during September 2020, entered into an agreement, a fuel supply.
You can proceed.
A fuel supply agreement which he himself had signed with Mr. Mulunga, Your Worship. The entity, rather Erongo Petroleum, did receive petroleum products to the value of 238 million. So as to whether there is no case against him, Your Worship, the state believes there is a good case and a strong case against him in this regard.
Direct the witness that, and this is a problem, Your Worship. The witness misunderstands his position. He is not the state. He does not, he is an officer, a public officer availing information to court, whether against the accused person or in favor of the accused person. That is the law. He is not a hired gun by the state. He is a witness called by the state. So he must therefore, he is not a representative of the state. He is a witness called by the state because he is funded by the public to do in an administration of justice. So it appears he have this wrong understanding that he is there to suppress favorable information to the applicants and only testify on matters that are in favor of the state. He's wrong. And your Worship, I will refer him to cases that are saying he must be impartial. He must stop saying that the state view is this. He's a witness, Your Worship.
Any comment?
I'll direct the witness. I don't think it was made with that intention, but perhaps is what is stated here. But I'll direct him. I understand the concern.
Okay, then
Yes.
we can proceed.
Yes. Mr. Inamba, just to direct you, when you answer the question, I'm not telling you what to say, but just from your investigation, just rather say there is a strong case from what, but if you say the state, it will appear they are saying you're a hired gun, as it is being suggested. But I'll move on to paragraph 65, and I'll read it to you. It says, in that agreement, before I get to that, it's an agreement between if the court can just bear with me, I'm getting to the agreement.
Just take your time.
There is just a suggestion that Ms. Gebhardt wants to give the copy of the affidavit to the witness because there is just one. Okay, Mr. Namba, at paragraph 64, and I want to make reference to an attachment which is marked LSN8. So I just want you to page so that we find LSN8 so that we're on the same page. Your Worship, unfortunately the documents are not numbered. I'm almost there.
Yes, I know they are not numbered.
Yes, but I'm getting to the document. I'm at LSN. Yes. Yes, okay. Yes. I'm not sure if you've found it, Mr. Nando. It's a fuel supply agreement. It's just after the bank statement. Did you find it?
Yes.
Okay. Now, we have, during these proceedings, referred to the fuel supply agreement between Namcor and Irongo Petroleum. And in your evidence, you did that. Do you recall that?
That's correct.
Okay, so I just want to, you can find something to put on the other page so that you don't get confused.
Okay, on the page.
Okay, so I have one flyer on paragraph 65, and then you have another one on the document titled LSN8. Okay. May I proceed?
Yes, you
Okay.
may proceed.
So, I'll read paragraph 65 to you, or you also have it, but I'll read it. In that agreement, the parties have expressly agreed to quantify of fuel to be supplied, the payment terms and brackets, including the cancellation of credit facilities in the event of non-payment, as well as a debt collection process and arbitration process in the event of any dispute arising between the parties. Of interest here, I just want to find out from you if you have a comment, because it is.
So sorry. I actually should not apologize. You should read the correct word. It says quantity, not quantify. Quantity of fuel. The two are distinct.
Yes, I appreciate that. Okay. So yes, it's quantity, not quantify. So I'm saying, in relation to what has been said with regard to the clauses that are in the agreements, it's being suggested here, or at least from my reading, not suggested, as it says, debt collection process and arbitration process in the event of any disputes arising between the parties. In other words, what has been the center of this case is that this should have been a commercial transaction which should have been solved in a commercial court through arbitration. What is your comment?
Your Worship, I agree that, you know, in a normal course of a commercial transaction, you know, the civil way of recovering, you know, the debt would have been applied. But Your Worship, the problem in this regards was the preceding actions which transpired, because, Your Worship, we have led evidence which indicates that there were money that was paid, or rather, funds were being paid to staff members who subsequently approved, or rather authorized, fuel to Erongo. As a result, therefore, an offense or offenses were committed in that regard.
With regard to yes,
I'm not an objection. I saw it yesterday and I expected my colleague to clarify, because it will be an injustice if we let it go. Yesterday and today, the witness continued testifying that in the normal course of commercial transaction, everything would have been fine, but the problem came because of preceding action, referring to payments later. I think he's referring to subsequent action. And I expected yesterday, I didn't want to dictate, but it's becoming a problem. He's actually using preceding instead of subsequent. I think if my colleague can just correct the witness so that there is justice in the matter is being handled, so that everybody is on the same. He's trying to say the problem became when there were payments subsequent to whatever.
Advocate Mulunga, do you understand?
I understand. Maybe just use an easy word, because maybe yes, the correct word there. I think that's when things are lost in translation. I understand the concern. Okay. May I move on, Your Worship? I think it has been resolved now.
Okay, yes.
Okay.
You can move on.
Okay. So I just want to proceed to paragraph 67 of that affidavit. It relates to the issue of that accused, the applicant being a Namibian, but I'll read to you. As stated already, I'm a holder of a validly issued passport, which I'm prepared to surrender if ordered to do so by the Honorable Court. In addition, I undertake to limit all traveling within the jurisdiction of Namibia and to adhere to any further bail condition in respect of my traveling. Do you have a comment with regard to that?
At this,
Before you answer, do you know where the passport of the accused is, or if he has a valid passport?
well, I know he has a valid passport, Your Worship.
Yes.
As to its whereabouts, only he knows where it is.
Has he not been handed to you?
No, it has not been handed or surrendered.
Okay. Okay, then.
Your Worship, Your Worship, the statement under oath states that the passport is valid, it's issued, it's in the possession of my legal practitioner. Then my colleague takes the very same statement, reads it, and asks the witness if the passport is in his possession. Without laying any basis, it doesn't. What is happening? It's unfair. And this witness just got this statement now. I'm sure he read it, but the applicant alleges that I have a validly issued passport. It's in the possession of my legal practitioner, and I'm ready to surrender it. My colleague simply reads the last part to the witness. We are really, I'm at odds.
Any comment?
That paragraph is not there. I was going to get to that. I think it should be done with caution that I'm not a prescription on how I conduct my questioning is not done, because I'm going to get to there. I do not just put questions that are favorable to the clients, but I'll proceed. Okay, so paragraphs.
Before you proceed,
Yes.
you read paragraph 67.
Yes.
Yes. Okay. Mrs. Gebhard, I see your concern, but on 57, that aspect you are referring to is not appearing. Maybe for now he's at paragraph 67. He is still coming to where your point is raised.
The issue is that allegation is made in the word that he's using, a preceding paragraph. So it's not coming, it already passed. All
Yes.
I'm saying is we need to be, let's be reminded what these proceedings are about and what that allegation is meant to address. That's the issue of abscondment. So if the allegation is that I have a passport, it's in the possession of my legal practitioner under oath. That's a statement under oath. And I'm prepared to surrender it. This witness can't be told only the surrender part. That is the only point I'm making, keeping in mind what the nature of these proceedings are and what that allegation is addressing in these proceedings.
It's really with time. There is a principle that if a matter is admitted, the court has no competency to seek to determine a dispute which is not there. If there is an affidavit under oath which says the passport is in the possession of a lawyer, why would a state counsel waste time to ask, do you know where it is? Honestly, Your Worship, my colleague can even hand it over to the state so that the disputes, all what we are trying to say, let's be fair to the proceeding, let's move fast.
Yes, no, we should be fair, and that is what I think the court is doing. You know, we started and we are still here, so the proceedings must take its course.
Yes.
Yes, but counsel indicated that he will move on. The concerns of Mrs. Gebhardt are noted. Yes,
Thank you, Your Worship.
you can move on.
Paragraph 68. This is very important, Mr. Inamba. Furthermore, I wish to reiterate that as soon as I became aware that the authorities were looking for me, I reported myself to the authorities and was arrested. Therefore, I have demonstrated that I did not attempt to evade arrest, nor is there a risk of me absconding the trial. Do you have a comment on that?
Your Worship, it is true that he presented himself to our regional office in the north, but I'm sure he was not aware that he was going to be arrested. Had he been made aware that he was going to be arrested, Your Worship, it would have been a different thing.
Okay. I just want you to substantiate. Do you know the circumstances under which he went to report himself at the regional offices in the north?
Yes, Your Worship.
Okay. Please tell us.
The warrant of arrest was shared with our regional office in Oshakati, who contacted him and informed him they were looking for him and wanted to speak to him. So from there, they made arrangement between the regional office and himself to meet, and they met the next day. So it's only after they met that he was informed he was being arrested, or rather that he was under arrest.
Okay. Just while we are still at that paragraph 68, from the applicants that are before court, apart from Mr. Nandaho, who reported himself, is there anyone that voluntarily came to the offices to report himself when you were looking for them?
That's correct, Your Worship. Mr. Peter Elindi was one of the people that came to the office. As he became aware that we were looking for him, he came with his lawyer to the office. And Ms. Dunaiski also brought herself to Windhoek police station, but she didn't know that she would be arrested as well, because we had contacted her relatives, and believe one of her relatives is a lawyer, and we did inform them we were looking for her.
Okay, when these two, at least three individuals for now, let me talk about the two, Ms. Dunaiski and Mr. Peter Elindi, when they were called to your offices, were they informed?
There was no evidence that my client was called to the office, please.
Or when he went?
And when I object.
Yes. Then we have the decorum.
Yes.
We maintain our decorum.
Yeah, there was no such evidence, please, that he was called. There is evidence he presented himself.
Counsel?
Yes, when he presented himself to your officers, was he informed that he was to be arrested, or what happened?
Your Worship, we were not able to speak directly to Mr. Peter Elindi, although we tried to call him with no success. And I remember calling a person that I know knows Mr. Elindi to see if he could assist to talk to him. But we never spoke to him. So when we arrested Mr. Malakia Elindi and his wife, upon returning to the office, that's when Peter Elindi arrived at the office with his lawyer.
On paragraph 72, just proceed paragraph 72 and I'll read it. The last ground on which the state objects to my release on bail is that it has a strong case against me. I humbly submit that I have demonstrated herein that the state's case against me is weak. And yes, is very weak. W-E-A-K. And on paragraph 73, it reads, even on the investigations conducted thus far, the state's case is very weak. Take note of the superlative, very weak, given the standard of proof required to secure criminal convictions in Namibia. Now, when regard is had to everything that we have said, is the state's case very weak against the applicant, Mr. Nando? Yes, please respond.
Your Worship, in terms of the evidence that has been gathered so far, the investigations has gathered sufficient evidence, Your Worship, proving that the offenses that has been alleged were committed, and Mr. Nando was in this regard involved. His entity benefited, or rather received an amount of 238 million, Your Worship.
I just want to alert you to proceed to go back to paragraph 12. I'll read it. It says, I'm a qualified plumber by profession, having obtained the following qualification from Valombola Vocational Center. And he lists the certificates. 12.1, General Construction, Level 1, Plumbing Certificate. 12.2, General Construction, Level 2, Plumbing Certificate. And paragraph 12.3, General Construction, Level 3, Plumbing Certificate. Now, I just want to find out from you, during your investigations, he said he's a qualified plumber. Did you establish whether he was employed fully as a plumber, or
I have to object. The allegation is not that he was employed as a plumber. My colleague just read it. I'm a qualified plumber. Here are my qualifications. But then the question he puts to the witness is whether the person is employed as a plumber. That allegation was not made. Full-time, in fact.
Yes, Counsel, I want to know whether that will assist the respondent's case, that aspect.
Yes, it's relevant in the sense that here is the person that was running this entity, but yet he says he's a plumber. I think that's the premise I'm trying to lay the basis. And I think these objections are also just premature without me having put the basis on which I'm putting the question.
Your Worship, in replying to my objection that I raised, as well as in response to the court's question, whether the issue of whether my client is employed as a plumber is relevant to these proceedings, my colleague does that issue of whether the objections are in his taste or not, but more importantly, he says to this witness that my client was running this entity. There's no such evidence from the witness. And we must be fair to the witness because he's coming to be cross-examined. He never at one point said that Mr. Nandaro was running this entity. He at all times said that at the relevant times, according to his investigation, the entity's 100% membership interest was held by Mr. Nandaro. He never said Nandaro was running this entity.
Is there anything else?
No. I'll put a different question.
Yes, because I see it will not assist. Yeah,
So-
we can move on. This
So-
the respondent's
yes.
case. We can move on.
So, Mr. Inamba, are you able to tell us what was the role of Mr. Nandaho at Irongo Petroleum CC? What role did he play, if any?
Your Worship, as far as the evidence established, he held the stake or other interests in this entity as far as the entity was established, I believe, Your Worship. I haven't looked at the founding statement and amended statement this morning to see. But during the period when the concerned petroleum products were supplied, he was the 100% owner. So as to whether he was involved administratively in administering the business affairs, Your Worship, that cannot be confirmed.
Sorry, I didn't hear the last part. That cannot be confirmed. Yes. Thank you.
You earlier on said his entity received an amount of 238 million. What does that mean?
Received petroleum products of 238 million from Namcor Trading.
All right. Now, with regard to, I just want you to comment on the grounds of objection. That is, if you have a comment.
Sir, what are you putting there before we proceed?
It's a bottle of water, Your Worship. Thank you. He's a colleague from the office.
Okay. Yes, on the grounds of objection, we have already touched on the issue of risk of abscondment. I just want you to comment, if you have a comment on the aspect of the applicant interfering with investigations. The aspect of the accused that he will interfere with the ongoing investigations. The applicant, Mr. Nandaho.
Your Worship, the nature of the charges that we are being investigating is serious, in a sense that it involves money laundering as well. And by nature, money laundering is complicated in a sense that there are various transactions that are happening and which needs to be followed. So we believe, Your Worship, that if he's released, Your Worship, he will interfere with investigations. In fact, Your Worship, as we speak, we did receive information regarding the applicant as to his involvement with Mr. Simaneka, who is currently not yet arrested, Your Worship, before he was arrested. And it's a leg that we are still actually trying to follow up as well.
Okay, just for the sake of completeness, perhaps if you are asked the information that you received, if you can, without divulging much detail, what information relating to what exactly?
Your Worship, without really divulging a lot of information, in fact, this information was just received, I believe, on Monday, Your Worship, where a source visited the commission and provided provided us information as to the whereabouts of Mr. Simaneka. And the actions which transpired shortly before Mr. Nandaho was arrested, Your Worship. And unfortunately, we could not follow it up now because we are here, and it's something that we still need to follow up and see whether it has substance, Your Worship.
There is also another ground that relates to the seriousness of the charges against the applicant. Do you have a comment with regard to the seriousness of the charges that he's facing?
Your Worship, the evidence that
That question has already been asked. The witness already tested. He answered already, please.
Counsel?
I asked about the weakness of the state's case, but now does...
Yes, that was already, in fact, yesterday and today. The witness already answered that question. Remember when you said they were saying, first he answered in general in respect of every party, and he answered already. Honestly, please.
Counsel?
Your Worship, if it's being suggested that that question was answered, but I disagree because I asked him about the case being weak. Now I'm talking about the charges specifically themselves, and I'm dealing with the applicant, Mr. Nandaho, because that's why I was reading the charges. It's in relation to Mr. Nandaho, and I think the objection is premature. It's just designed to stop me from asking the relevant questions. So it's about the charges, not the case in general. The charges specifically with regard to Mr. Nandaho. That's what I'm asking the witness.
Yes, Counsel, can we just maintain the decorum? When you have an issue, just address that issue without dealing with any other.
Yes.
Yes, I understand the objection is overruled. You can proceed.
Okay.
Because this one appears that it's specifically for the seventh applicant.
Yes. Please. You.
Your Worship, the charges are serious. One of them being fraud, which is a Schedule 2 offense, Your Worship, in terms of the criminal procedure. And as indicated, Your Worship, there are charges also pertaining to money laundering and as well contravening the Anti-Corruption Act, Your Worship, which are equally serious charges, Your Worship.
All right. Just before I move on to another aspect, on paragraph 46, it actually slipped my mind that I didn't ask you. I'll read it to you. It says, during my tenure as member of Irongo Petroleum, I played no role in the operations of the business apart from signing documents that require the signatures of the members. The operations of the business were attended to by Austin. Do you have a comment on that paragraph there?
No comment, Your Worship. I believe it speaks for itself, so no comment.
All right. Before I move on to another aspect of the other applicants, I just want to ask you a question. Just trying to get the document.
Just take your time.
It's a piece of paper where I wrote. found the document. Just before I conclude with you, sir, there is one important question I need to ask you. Just to summarize, I need you to connect the dots or to assist the court to explain the relationship between the following entities which are involved here. Firstly, there is Enercon Namibia Pty Limited, there is Eco Trading CC, there is EcoFuel CC, there is Onyeka Clearing and Forwarding CC, Quality Meat Supplies CC, Erongo Petroleum CC, and Venus Technology CC. I don't know if you got them, but yes. Just the relationship with regard to the present case. How related or interconnected, if any, are these entities?
Your Worship, although by virtue of registrations, entities are held by different individuals, Your Worship, if I could just maybe just paint, a picture of a tree, for example, Your Worship. Venus is owned by Austin Elindi.
Yes, the name
Yes.
in full.
Venus Technology is owned by Austin Elindi, who is the son of Mr. Peter Elindi.
Yes.
Eco Trading is owned by Mr. Simaneka. In terms of the address listed on Eco Trading and EcoFuel Investment, they are having the references of the residential address of Mr. Peter Elindi. At some point, one of them, I believe, it's EcoFuel Investment. At some point, it was initially owned by Victor, Simaneka Malima, and Austin, and it was called V&A Trading, but it was renamed. So, still they are connected to Mr. Peter Elindi. And if one looks at Onyeka was at some point owned by Mr. Peter and Mr. Malakia Elindi, who are brothers. And subsequent to that, the interest changed to Lydia Elindi and Malakia Elindi, who holds 50% interest. And we know Lydia is the wife to Mr. Malakia. Nyambali Medical is owned by Mr. Peter and Malakia Elindi, who are brothers. The only one which I can say is perhaps Quality Meat Supply, which is owned by Hileni Itana. I'm not sure what is the relationship by Hileni Itana to the other people that I've mentioned, but we know that in terms of the beneficial ownership, it's owned by, the beneficial ownership is for Simaneka Victor Malima. Your Worship, you could say, they are branches of the same tree as far as the relationship are concerned. There's no way you can divorce one from another because you have transactions flowing from one business to another. Erongo, we know currently it's owned by Austin, Your Worship. Not sure if I omitted any one of them, but they are they are close. They are for family members, I can say.
Just to conclude, I just want us to deal with the grounds of the objection. With regard to the first applicant, Mr. Peter Elindi, on the risk of absconding, do you have a comment on that?
Your Worship, the risk of abscondment is there, in a sense that the charges he's facing are serious charges. It's charges of fraud, charges of conspiracy, and charges of money laundering. They are serious offenses, Your Worship. So the risk is there, the means is there, Your Worship, in terms of funding. So I believe the risk is there, Your Worship.
And still with the first applicant, what about the issue of interfering with the witnesses?
Your Worship, as I indicated earlier, the nature of investigations that we have been conducting is very complicated, in a sense that, transactions were complex, moving from one account to another and so forth and so on. Your Worship, we already have, it's in respect, my apologies, Your Worship, I almost said something else. But what I'm saying, Your Worship, is there is a very high degree that, interference to investigations may occur, as we are still busy tying up few issues here and there, Your Worship, especially relating to some of the financial transactions.
What about the issue of public interest or the administration of justice with regard to this case? If you have a comment, if you don't, then you can say so.
Your Worship, the issue of public interest and as well as the interest of the criminal justice, Your Worship, it is a serious offense in the first place. And I believe the public is also concerned. Your Worship, the offenses that are being investigated is offenses of economic in nature, which has significant impact on the economy, and this goes to as how the world also views us as a country, Your Worship, and therefore I believe that carries an element as well, Your Worship.
I'll move on to Mr. Elindi, Malakia Elindi, the second applicant. Still the same ground. We start with the interfering with witnesses. Do you have a comment, or is it just the same?
It's the same, Your Worship. I think in respect of Mr. Malakia as well, I think maybe what I didn't mention earlier, which I can mention slightly different, is the value that is involved. It's a big sum that is involved, Your Worship, and should they be found guilty, Your Worship, I'm sure the penalty might be serious as well.
Can the witness just stick to the answer question? My colleague, in all fairness to Advocate Rirunga, simply asked the witness about interference, and the witness gave a lecture about amounts. It's becoming...
Yes, we can proceed. Yes.
You can just stick to questions, please.
You can proceed.
Yes. With regard to, yes, the second applicant, Mr. Malakia Elindi, the risk of absconding, you have a comment there?
Your Worship, during the investigations, we had established that Mr. Malakia at some point lived in Dubai, if I'm not mistaken, Your Worship. And I'm saying, Your Worship, the risk of abscondment is there for any of our accused person, including him as well, Your Worship.
And the seriousness of the charges, would it just be the same or different from what you have
Yes.
earlier mentioned?
Yes, Your Worship, the charges are serious. And therefore, the risk of abscondment, Your Worship.
With regard to the fourth applicant, Mr. Mulunga, the seriousness of the charges, do you have a comment around there?
Yes, Your Worship. The charges are serious. Charges of fraud, money laundering, and corruption, Your Worship. That's serious charges, which can result in a serious penalty, Your Worship.
And with regard to the issue of public interest and administration of justice in relation to Mr. Mulunga, fourth applicant?
Your Worship, I believe there is public interest, especially considering that Mr. Mulunga was, holding a public, rather he was the managing director and the accounting officer of Namcor, where the concerned funds, Your Worship, Namcor as a result has, suffered an actual, prejudice. Therefore, Your Worship, public interest is there, and as well as the interest of the justice system in this regard.
The fifth applicant, Ms. Jennifer Hamukwaya, with regard to the seriousness of the charges, do you have a comment?
Your Worship, I'm not sure if I'm allowed to go back
Yes.
on
you
the
can.
issue of interference with investigations,
Yes,
when it
please
comes
do.
to Mr. Mulunga, for example.
Please do.
Your Worship, and I'm mentioning this one because the vehicle is not there. This is a sign of interference with investigations, Your Worship, and I just wanted to make sure that I put it on record that that risk of even further interferences exist.
Yes, you can proceed. I had asked you with regard to the fifth applicant, Ms. Jennifer Hamukwaya.
Your Worship, in terms of the charges, they are serious. They are serious. She's facing charges, among others, corruption, money laundering, and as well as fraud, Your Worship. These are serious offenses, and which can one can try to escape justice, Your Worship, or evade justice in that regard.
What about the risk of absconding with regard to Ms. Hamukwaya, Jennifer Hamukwaya? You have a comment around that aspect?
Your Worship, because of the seriousness of the offense, the likelihood is there, Your Worship.
The aspect, I don't know if I asked you this, with regard to Ms. Hamukwaya interfering with the witnesses, do you have a comment around that aspect?
Your Worship, given the fact that the accused person has been arrested, Ms. Hamukwaya has been arrested, given the opportunity to be out there, Your Worship, I believe investigations, or rather, will be interfered with because the investigations is not yet completed, Your Worship.
Your Worship. Your Worship, I observed the trend and the very unfortunate trend by the witness, the investigation officer, rather than testifying on facts, personal facts arising from his investigation, he keeps on saying, I believe. This is not a church. He must speak to the personal knowledge arising from his personal investigation. If Mrs. Hamukwaya tried to abscond and she was stopped, that will be very relevant to this court. Not about beliefs and opinion. That is against admissibility of opinion evidence. The opinion evidence is not admissible. Only the court can make an opinion based on proved facts. Please, the court, your worship.
Counsel, any comment?
Well, in bail proceedings, hearsay evidence is admissible. So I think I'll just ask the witness if he can rephrase, because I think from the onset we know that in bail proceedings hearsay evidence is relaxed and the rules of evidence are also a bit relaxed. So I do not think the witness intended it with malice to say that, but I will just ask him to rephrase. Instead of saying I believe, just tell us what you uncovered in your investigations.
Sir, do you understand?
That's correct, Your Worship.
Yes. We can then proceed.
With regard to Ms. Dunaiski, the sixth applicant, let's go through the grounds, just like I've asked you. Interference with witnesses. Do you have a comment?
Your Worship, investigations has established that some of the witnesses we approach to obtain evidence, they are a bit afraid. So the risk, Your Worship, even with Ms. Dunaiski, is there, that the possibility for interference with investigations may happen.
What about the seriousness of the charges with regard to Ms. Dunaiski as well?
Your Worship, we have given evidence which demonstrated the charges are serious, and therefore, Your Worship, there are serious charges, which we believe, Your Worship, if found guilty, she can be imposed, with a serious sentence, Your Worship.
The other grounds, if you have a comment that relates to the administration of justice, the risk of absconding as well on Ms. Dunaiski, do you have a comment?
It's same with the others, Your Worship. The public, there is public interest as far as the case is concerned, because this money is the money that was lost from subsidiary of a public institution, and the value, Your Worship, it's not a small amount, it's a big amount, and therefore every citizen of this country should be concerned, as well as the justice system, Your Worship.
And lastly, with regard to any of the grounds, but I will be with Mr. Leo Stefanas Nandaho, with regard to interference with the witnesses, do you have a comment around that?
Your Worship, let me not comment for now, Your Worship.
The seriousness of the charges that take into account I think it's paragraph 42 that I've stated that he says he had.
Why I didn't comment, Your Worship, is because I thought we finished Leo, and that's why I did not want to contradict myself.
I do not think it's a laughable thing. The evidence has been overwhelming. I do not intend to do that intentionally. Okay. But then, Mr. Nambao, do you have anything to add in conclusion with regard to the charges against the accused persons? They are taking into account the grounds of objection in respect of any applicant that is before court. Perhaps something I didn't ask you that you want to bring to the attention of the court?
Maybe, Mr. Before you proceed, I just want you to clarify. You have spoken about interference with investigations, but on the record, unless, correct me if I'm wrong, I did not hear you say this or that investigation is still outstanding. Do you understand?
I understand your worship.
Yes. So do you have any comment on that? What investigation is outstanding, if any?
Your worship, a lot has been done in terms of the investigations. There are a number of suspects which still needs to be apprehended as part of the ongoing investigations. And your worship, we know that one of the suspects had fled the country, your worship. And the likelihood, your worship, of interference has been very high as far as the information that we are receiving. And hence, your worship, I've mentioned, Mr. Nandaho, that some of the information we received is as recent as just before he was arrested, your worship. Your worship, the investigations, among others, is also looking into, the complicated financial transactions, your worship. As far as the charges of money laundering, your worship, you would remember, your worship, that we have demonstrated that this money moved from one account to another and so forth and so on, your worship. Your worship, there were a number of assets that were procured, which the investigations is also still identifying, your worship. And therefore, your worship, the investigations, it's still ongoing. And your worship, hence the fear that should any of the accused be released, your worship, they will interfere to a great extent as far as that is concerned, your worship.
Yes, you were on the conclusion aspect. You can proceed.
Unless the witness has something to add, that will be evidence in chief. Did you have anything to add? Before maybe I've cut you short, you want to add anything?
No, your worship.
Your worship, before we commence with cross-examination, just a 5-minute health break, then we can proceed. Just 5 minutes. We don't need a lot.
The court then briefly adjourns. We can proceed.
The court, please commence with cross-examination on behalf of applicant number 1 and 2. Your Worship, just for housekeeping, can I ask the court to have Exhibit D1 closed by you, Your Worship, and D2? And I have an additional cross-examination bundle, and I have provided my colleagues with copies, as well as with the witness, Your Worship. We will give it a name at a later stage, Your Worship. So those three documents will mostly be the one being used by me in cross-examination, Your Worship. May I then proceed?
You can proceed.
Now, Mr. Inambao, you told the court that you have worked for the Namibian police.
That's correct.
You must have undergone training as a police officer.
That's correct.
Where you did that also entails being trained on the imperatives and provisions of the Namibian constitutions, including the one about liberty of individuals?
That's correct.
Have you been trained on the provisions of the CPA, that is the Criminal Procedure Act, relating to when to arrest and so forth?
That's correct.
I must assume that you must have also gotten some trainings as far as the Anti-Corruption Commission is concerned, including training as to when to arrest and for what reasons.
Your Worship, that's correct.
Have you come across a judgment of Hairuru versus the Director of Anti-Corruption Commission?
I know about it, but I haven't read it.
Why have you not read it? It's an important judgment that criticized your colleagues as far as arrest is concerned. Why have you not read it?
Your Worship, I indicated I haven't read it, so...
Okay, so should I take it you do not know what it says about what you should do when you decide to arrest somebody?
I have no comment, Your Worship.
Why do you not have comment?
Well, I'm not sure the relevance of the question to me right now. You can just go ahead and ask me what you want to ask me.
Sir, I will ask the court to direct. It's not for you to determine relevancy. Answer questions. If you cannot answer, it's fine. I will use it against you.
Yes, I said I have no comment for that question.
Okay, let me just advise you. It's not for you to decide what is relevant. You understand? Do you understand?
I do not know whether he's warning the witness or what. I think he must just treat him with dignity. He has stated his reasons. I think he must respect the witness and not threaten him to say, do you understand?
With greatest respect, Your Worship. This is all what we do when a witness is telling counsel about it's not relevant. In fact, the court, Meromotu, can immediately say it's not your duty to do that. I simply ask, do you understand?
So do you understand?
Your Worship, I do.
Okay.
We can proceed.
Now, can you take the white bundle, and Your Worship is a new bundle I'm talking about, and can I ask you to go to page 60? Your Worship, the new bundle at page 60. That is the judgment of the Supreme Court, or the High Court by Justice Judge President Damaseb. Can you read out paragraph 98 at page 60? Read it out.
I am satisfied that the applicant has made out a case that respondents failed to apply their mind to whether or not it was necessary to effect arrest of the applicant instead of simply summoning or warning him to appear at court to answer the charges.
Okay, now.
He therefore,
Yes, no.
he therefore, you asked me to read the paragraph and I want to.
No. I will. I'm the one. When I say stop, just stop. You will read. Now, do you realize that now, as far as the High Court is concerned, our jurisprudence is that the arrester needs to consider whether or not an arrest is necessary as against summoning a person or warning a person. Do you have comment on that?
Your Worship, among the other considerations, there are various ways in which an accused or a suspect's attendance can be secured to court.
Yes.
Summons
Warning.
warning being one of them. And
And-
so is an arrest as well.
Yes, that's what I'm saying.
Yes.
The most invasive one is the arrest. The most gravest one in terms of intruding in people's liberty is the arrest. Do you know that?
That's correct.
And the less harsh one are the summons, warning, and indictment.
That's correct.
Okay. I will come back to that issue. Now, you realized this morning that I objected to the manner you were referring to yourself as part of the estate when you were testifying. You remember?
Yes, I do.
Now, during your training, were you ever trained that when you give evidence and when you do your work as an investigating officer, you must be impartial and objective in doing your work?
In fact, Your Worship, that is the objective of the investigations, is to be impartial and to be objective.
Okay. Do you agree with me that role and the nature of your work to be objective, fair, and impartial also include in bail applications?
That's correct.
That will mean that it's not open to you to suppress information that is in favor of an accused person during bail application. If there is information that is in favor of the accused person on the charges, on matters pertaining whether or not he will abscond, you must avail that information to court. Do you agree with me?
I agree.
It's not for you to suppress or conceal information that is in favor of the accused. You agree?
Yes, when it's in favor of the accused, yes, I definitely agree.
Okay. So, and it's not your duty, to exclusively tender evidence that only supports the objection to bail. Do you agree with me?
I agree.
Okay. When you testified yesterday and today, did you subscribe to such requirements? Did you conduct yourself in accordance to such requirements?
As far as the evidence I provided before the court, Your Worship, I believe it was objective because it was objectively obtained during the investigations.
Okay, turn to the record, Your Worship, the new bundle, the white one. Can you go to page 124? That is a judgment in a bail matter authored by Justice Maritz and Damaseb again, in the High Court, S versus Swanepoel. Are you at page 124?
I'm there.
Now, can you read the last 4 sentences of lines of paragraph 2, which start with Mr. Kutondokwa? If you can just read it out for the record.
Mr. Kutondokwa concedes, in our view correctly so, that he did not present his evidence in an objective and unbiased fashion as he expected, as is expected of a police officer entrusted with investigations of a case, Hence, I am reluctant to attach much weight on his opinion.
Yes, that is, Mr. Kutondogo was the prosecutor, but the statement pertains to the investigating officer. So do you understand the caution by the High Court that one should not seek to testify in a manner that is biased? Otherwise, your evidence will not carry weight. Do you understand that?
Your Worship, I've just read half of this. I didn't read the other context.
Yes,
so for me to commit to whether
yes.
I understand it or not.
Read the paragraph, I give you time. You read the whole paragraph. If that paragraph, the second one.
Yes, must I read it in full?
Yeah. Just take your time and you don't need to read it so that you answer. Maybe just read it from whichever. Yes.
Yes.
Whichever it is. Yes.
Whichever it is a matter to be determined by the court before which the appellant is likely to stand trial in due course. I should perhaps pause here to say that the investigating officer expressed strong views about the strength of the state's case against the appellant. The court will, of course, have regard to such views as was pointed out in State versus Duplessis and another 1992 NR 74 HC in bracket. The court is, however, not bound by those views. What is of some concern to us is that the acronyms, manner in which the investigating officer gave his testimony suggested that he entertained a degree of animosity towards the appellant or her legal representative.
Yes, the other part you read already.
Yeah.
So you understand what it is meant, that one must be unbiased.
Yes, give me a second just to, I've just read it, so
Okay.
I just want to make sure that I complete it. Yes, I understand.
Yes, so you agree with me that if you seek to behave as if you are there as a part of the state to exclusively tender evidence in support of the objection, and you are partial in that way, then you run the risk of your evidence to carry less weight. This is actually what is meant by the two judges of the High Court.
Yes.
Okay. Now, I will deal with about 4 broad areas in cross-examination. The first one will to test whether or not you went into something that you understand, investigating this commercial transaction and so forth. The second one will be whether or not the arrest was necessary. The third one will be that to demonstrate to you that, in fact, you did not even come closer to the standard required to arrest my clients. You shouldn't have arrested them. And I will then end in demonstrating that you have no case whatsoever and that you abused your power. You understand? So understand me when I ask questions. Now let's start with the first one. Have you done law of contract?
No, Your Worship.
Commercial law?
No, Your Worship.
Not at all. Whether at varsity or listen to me. Whether at varsity or at work to enable you to competently investigate commercial crimes.
Your
Are you
Worship.
saying you have never done even a basic case in law of contract or commercial?
I haven't done, any qualifications relating to law of contracts, Your Worship.
Yes.
Your Worship, yesterday the court asked what my qualifications were, and I did demonstrate what qualifications I possess, Your Worship.
So the answer being?
I answered already. I said no, I didn't do.
Okay, but so I will assist you. It's fine. Now, do you know, have you heard of something called voidable contract? Not void, but voidable.
No, Your Worship.
You have never heard about it. Now, I want you to go to the bundle page 180. Your Worship, page 180. Your Worship, for your notes, the witness is being referred to that case of Bowditch versus Peel, judgment by Justice Ines, Chief Justice, and I just want the witness to read a portion before I proceed. The last 4 sentences. Mr. Inambao, at page 180, read from that judgment the last 4 sentences, starting with a person.
A person who has been induced to contract by material and fraudulently misrepresentation of the other party may either stand by the contract or claim a rescission.
A rescission.
A rescission.
Okay, just hang on there. Rescission is a cancellation. Or do you understand what it means?
No, I understand.
Okay, you understand that rescission means cancellation.
From what you said.
Yeah,
I said I understand.
Say, when I say stop so that if you are not looking at me when I ask, otherwise you fall into...
No, I wanted to make sure that I put my finger where I stopped.
Okay.
So when you ask me to continue, I can easily continue.
Okay, no, it's fine. So now, do you understand that it's saying if a person, in this case can be a company, is induced to enter into a contract by a material and fraudulent misrepresentation, that party you can choose or you can elect to stand, in other words, to keep the contract going, or you have an option in law to cancel. Do you understand such a simple principle? You do now understand?
Yeah.
Okay. Can you read the next one? Read, you can skip foot 4.3 and whatever. Start with it follows.
It follows that he must make his election between those two inconsistent remedies with a reasonable time. Within a reasonable time.
Yes.
Must I continue on the next page?
Yes.
After knowledge of the deception.
Yes. Proceed.
And the choice of one necessarily involves abandonment of the other.
And the most crucial part?
He cannot both approach and reprobate.
He cannot both approbate and reprobate. Okay. Let's just stand there. Now, the first paragraph, which says that if you are saying you are induced by fraud to enter into contract, you must make a choice. Decide whether you want it nevertheless to continue or you want to cancel. Do you understand? That is a simple contract.
Yeah.
But you cannot be jumping around on this. Today you are saying you are canceling, tomorrow you are saying the agreement is going on. You must make one choice. You understand that simple contractual principle?
Yeah.
Okay. I just want to ask you, and I want to give you a letter at page accused number 1 bundle, that is exhibit, your Lord, your worship, B2, E2, your worship, exhibit, assistant, if you can assist court, please, with E2. Yes. Page 8-9. Remember, the allegation.
Still getting to the page.
Yes. That.
Is the court at page 89 where there is a
89,
letter? there?
yes.
Yes. Now, remember, you have spoken about a lot of fraud, and there are charges that Namcor was induced by fraud and so forth. Remember, that is the background. And there is a asset acquisition or purchase agreement.
That's correct.
So in other words, the principle that I just dealt with is very, very relevant to the issue that we are discussing, because you made the allegation that Namcor was induced to enter into an agreement through fraud. Now, the letter, have you seen that letter of the 5th of October addressed to Enercon? 5th of October, Your Worship, 2023, addressed to Enercon, and written by one Mr. Shiwanan Deunyema, Acting Managing Director. If you look at page 90, Your Worship. Have you ever seen that letter?
Yes, Your Worship.
Okay. If you have seen it, something must have struck you immediately. And I want you to read it for the record. It's paragraph 5. Can you read out paragraph 5 for the record? And keep the principle we discussed with you in mind. Can you read it out for the record? This is Namcor now speaking to Enercon in October 2023.
We hereby retract the fact that
No,
the asset...
reiterate, not retract.
Ah, my apologies, Your Worship. We hereby reiterate that the fact that the asset purchase agreement between the parties thereof remains therefore remains intact, valid, and binding until such time as the conditions of the reinvestment of the funds stated under clause 2 above is met, and the settlement agreement is signed between the parties.
Okay, just hang on there. What is your investigation? Namcor, did it decide, it appears in this letter that it decided to abide by the contract, assuming there was fraudulent misrepresentation. It made, remember, you cannot probate and approbate, reprobate.
Yeah.
It appears from this letter, Namcor decided to abide by the contract. Hence, they are saying this agreement remains intact, valid, and binding, more than a year after it was entered. Do you agree with me?
Not that I agree with you in totality, because, you know, remember when you are looking at the civil aspect, and this is what Namcor was trying to, I believe, mitigate. They were still trying to see if they could...
No. I don't care whether it is civil or criminal. I'm asking you, it appears from this letter that Namcor did, in terms of the law, choose not to void the agreement, but to abide, hence tearing Enercon. The agreement remained intact, valid, and binding. It made a choice in accordance with the law of contract and commercial law.
You want me to respond?
Any comment?
No comment for now, Your Worship.
Yes, there will not be a comment because it's a fact. Let's proceed for a while. Do you know that at the beginning of this case, there were preliminary charges that were furnished to my clients on the date of appearance in court? Do you know that?
That's correct, Your Worship.
Do you know that we complained bitterly and that we want specific and clear charges so that we are able to defend our clients in the bail application? You must have known that.
I knew that.
Because of that, we were told the prosecutors are going to consult the investigating officer, come up with clear and concise charges. And we were then given what was called complete and clear charges. Do you know about that?
I'm aware of it, Your Worship, but I believe the charges are still preliminary because of the amount of time that the state had to, or rather the prosecution team had to come up with the charges.
You don't trust them?
Your Worship, investigations are still going, and at that point in time, they needed to.
You don't trust the, no, I'm saying, no, I asked you that we were told these are the concise charges because we protested. Did the state mean it? Did the state mean it? You are assisting the state in terms of the charges, or I'm trying to say, did you cooperate, were you consulted when the charges were framed? Were you consulted?
Yes, I assisted to.
Okay. So that means that if my clients, the Elindis, are accused of committing fraud on the 15th of July 2022, that must either have come from the docket or from you. I'm referring to, if you can take the next bundle, may I ask the court to take D2.
At what page?
D2, at page, starting with fraud charge against Mr. Peter Elindi at page 14, D2. 14.
The one on top.
Yeah, yes. But at page 14, Mr. Inamba. Now, you see that the date we were given is specific, that my client made misrepresentation. In other words, fraud alleged was committed on the 15th of July 2022. You see that? In the fraud charge, count number 34.
15th of July 2022?
Yes.
Yes.
And that is the date. Both Mr. Malakia Elindi and Peter, the charge is the same. Fraud was committed on that date. You see that?
I see that, Your Worship.
Yes.
But other than just seeing it, it's perhaps better for it to be read so that it makes context, because otherwise it's just a date.
No, sir. It doesn't work that way. All I'm asking you, do you see that it is said fraud was committed on the 15th of July 2022 at Windhoek?
Yes, that I see.
Okay. And you agree with that?
Your Worship, and hence I was saying, without completing the charge, I'll not be able to confirm as to whether I agree or not.
Look at the charge. Let me give you, what do you want to check? Look at the charge.
It's not what I want to check. You asked me if I agreed, and I'm saying I cannot agree if I haven't read the charge.
Say, are you not the investigating officer? The charge says my client committed fraud on the 15th of July 2022, and they were prepared with your assistance.
Mr. Namanje, I'm saying I needed to read the charge other than me committing to a date
Your
alone.
Worship, can the witness please answer a simple question? It cannot go on like that.
Yes, he confirmed the date 15 July. The next question was, do you agree with the date 15 July 2022? As per that charge.
Your Worship, and that is what I could not agree to, because I haven't read to see what the charge entails. Yes, it says fraud on this date, but I needed just to verify to see what the context of the charge.
Read, it is there, a few paragraphs. It's
you.
your charges.
Thank you, and that's all I wanted to do.
Yeah, okay, sir, just proceed.
Shall I read it silently or?
I think the witness is playing with respect.
Whereas the accused, okay, let me start from the beginning. That the accused is guilty of the crime of fraud, whereas the accused did on the 15th 15th day of July 2022 at or near Windhoek in the district of Windhoek, that did wrongfully, unlawfully, falsely, and with intent to defraud, give out, and pretend to Namcor. There's a B, that he was to sell 9 service stations to Namcor while he was not in a position to do so.
Yes, before you proceed, the question was just whether you agree with the date 15 July 2022 as stated above.
Yes, Your Worship, I agree with the date.
Okay. That, I will note it down. So, and who committed fraud on that date?
Your Worship, the charge here, charge count 34, Your Worship, is for Peter Hango Elindi.
No, yes. So, are you saying he committed fraud on the 15th of July 2022?
Yes, Your Worship.
Okay. By doing what? What conduct, what action or omission occurred on the 15th of July?
And Your Worship, this is why I wanted to read this in fully but I'm going to answer you. On the 15th of July, this is when Mr. Malakia and Peter Elindi accepted the commercial offer that was made by Namcor to purchase the assets.
Okay, so I'm very specific. I'm very sensitive with words. So remember, I asked you, fraud is committed through
Mr.
an act,
President.
a conduct.
Yes.
If it is a concealment, it can be an omission. You agree with me? Do you agree with me, Mr. Investigating Officer?
I agree with you, Your Worship.
Okay. So the act, in other words, what they did to commit fraud, according to you, is accepting a commercial offer. Is that what you say?
Yes, Your Worship.
So someone must have made an offer to them.
That's correct.
Remember, corporate entities do not speak, do not walk, do not communicate. They act through persons, individuals. Do you agree with me?
Agreed.
Okay. Who is the person that made an offer on behalf of Namcor?
Mr. Mulunga.
And on the part of Enercon, the persons who accepted, you say, is Peter and Malakia. Is that correct?
That's correct.
So as far as fraud is concerned from Enercon's side, it was executed by 2 directors by accepting an offer. Is that correct?
That's correct.
Who made misrepresentation to whom?
Your Worship.
On that day.
Your Worship, I believe all the accused that are charged with the same offense, including...
Sir, who made misrepresentation in fraud? There must be a person, a company doesn't speak. Somebody must be a victim. Somebody must be misled and induced to act at his prejudice. Let's deal first with the person who made the misrepresentation. Who was that?
Your Worship, both Mr. Malakia, Peter Elindi, and Mr. Mulunga.
Okay.
Namcor Trading is the one which ultimately suffered a prejudice at the end of the day.
I'm not asking about prejudice yet. Listen to the question. Prejudice is another element. I'm simply asking you. So you said now misrepresentation was made by the 2. To whom? No. You are saying are you suggesting that misrepresentation was made by 3 people? Are you saying that?
Yes, Your Worship. I believe Mr. Mulunga has a charge of fraud as well.
No, I'm not asking whether Mulunga has a charge. I'm asking something specific on my client. what happened on the 15th of July.
I answered it, Your Worship.
Okay, let's go over again. Peter and Malakia Elindi, you said they made misrepresentation by accepting a commercial offer. You say that under oath.
That's correct.
When they accepted the commercial offer, Mr. Mulunga was not acting for Enercon.
That's correct.
So it is them who accepted the commercial offer. Is that correct?
That's correct.
And that is what you call a misrepresentation.
Your Worship, if you look at the commercial offer alone, one cannot really say it's a misrepresentation. It's the subsequent actions that transpired after the offer was accepted, Your Worship.
No. Don't tell me. Tell the court about the offer. I'm asking about the acceptance. Those are two different things. Because you say, on the 15th of July, Mr. Mulunga and Malakia committed fraud by making a misrepresentation when they accepted a commercial offer. So all I wanted to know, Mr. Mulunga, on your version, is not in the acceptance by Enercon. It's not part of it.
Of course.
Okay. If acceptance is the misrepresentation, it must be targeted to somebody. Is that correct?
Yes.
And directed to somebody.
Yes.
Okay. Before we proceed, remember the elements of fraud. Do you know them?
I know them.
It's an intentional fraudulent misrepresentation directed to someone who is, of course, the victim, with an intention for that person to act at his or her prejudice. Do you understand?
Your Worship.
Just listen.
I understand.
You understand? Okay. Now, to whom, not Namcor as an organization, because it doesn't speak, to whom was this misrepresentation was directed as acting for Namcor so that that person act at his prejudice? Who is that individual? The victim.
Your Worship, as I indicated, neither the board members would have suffered an actual loss. Namcor suffered the actual loss, and that is where the prejudice.
Sir, listen to my question. I will come to prejudice. I'm not dealing with that. On the 15th, there was misrepresentation made, you said.
That's correct.
Who was targeted? To whom was it directed? So that that person on that day act at Namcor's prejudice.
Mr. Mulunga.
Okay. So then Mr. Mulunga is the person who was misled to act at his prejudice. So then he's the victim.
Your Worship, I can't say Mr. Mulunga is the victim because he was representing Namcor Trading.
Yes, I know, but elements of fraud, a misrepresentation goes to somebody so that you are misled to act at your prejudice. Here, Mr. Mulunga is representing Namcor. Namcor doesn't speak, sir.
Your Worship, when people act with a same common goal, they can still commit fraud against an entity.
Oh. Was somebody misled? Not Namcor. An individual representing Namcor on the 15th. Was somebody misled?
Your Worship, as far as the evidence is concerned, Mr. Mulunga represented Namcor.
Was somebody misled on behalf of Namcor?
Yes, Your Worship.
Yes. Who is that?
Mr. Mulunga.
Okay.
Yes, Lord.
Very good. That's what I wanted. Where is Mr. Mulunga?
He's here in court.
As an accused person.
That's correct.
Notwithstanding, he has been misled.
Your Worship, and when we look at the charge,
Notwithstanding him.
yes,
Object. I think if the witness is still answering, he must let him complete his question and then proceed to the next
I
question.
apologize.
It's
Okay,
in
sorry.
order, yes.
Yes, I
The
apologize.
apology is accepted. We
Yes.
can move on.
Okay, remember you said he's the one that was misled by my clients on the 15th? Tell us, you were explaining?
yes. I'm saying, and this was the reason why I initially wanted to read the charge. Because you see, when you
We
look
are
at the
past
charge,
that.
it says Namcor, because he represented Namcor.
But that we know, that is not in dispute.
Okay, sure.
That's why I explain you the basic. Companies do not speak. They are not human beings.
Of course.
When a company is a victim, is because one of its director or employee was misled, and you chose Mr. Mulunga. Is that correct?
I didn't choose him. He is the person that gave the offer, the commercial offer on behalf of Namcor Trading.
No. I will come to that. Okay, now, how was Mr. Mulunga misled? Set it out, I will summarize it. Let's go. Do you know what is misleading?
Namcor Trading, through Mr. Mulunga, made an offer to acquire storage facilities,
Yes.
bulk fuel storage facilities.
Yes.
Those storage facilities has never been acquired by Namcor to date, or Namcor never enjoyed the opportunity of.
Okay.
So had Enercon or the directors of Enercon indicated that they were not in a position to sell those assets to Namcor, they could have done so. And
Okay.
they,
But Mr. Mulunga testified in this court. He's actually the one who offered to my client. The offer came from Namcor, not the other way. The offer to purchase came, there must be an offer in contract and acceptance. Do you understand?
I hear you.
Which comes first?
Your Worship, it's clear that the offer was made by Mr. Mulunga.
Okay. Now, before he made an offer, there was no misrepresentation. You said misrepresentation happened on the 15th of July. So he was never induced, because the misrepresentation you will rely on is after the event.
Your Worship, the offer was made on the 15th of July. and it's-
No, on the 8th, sir. The commercial, you don't know your case.
My apologies.
Yes. The offer was
Yes.
made on the 8th.
Yes, the offer was made on the 8th.
Yes. But I think you don't
No,
understand.
wait.
Yes.
Yes, the offer was made on the 8th
Okay.
and accepted.
On the 15th.
No. The asset purchase agreement was signed on the 15th.
Yes?
Not the offer was already signed by the 15th.
Yes. But you are the one that told court today that the acceptance was made on the 15th. I'm just going with your evidence.
No. We were going on the charge.
Yes.
Eh,
And I asked you what happened on the 15th, and you said they accepted. Everybody's writing down.
Oh, then, and that was the reason why I really wanted to go through the charge.
You
before.
continue going there. We are done with
Okay.
that.
No. On the 15th, that was the the asset purchase agreement that was signed.
But that's how it works. First, there must be an offer.
And we agree.
Okay.
There was an offer which was accepted.
So, seriously, you are becoming dangerous to your own case. Look, there is an element of inducement in fraud. Do you agree with me? That you must be induced to act to your prejudice. Do you agree?
Of course.
So if there was no misrepresentation prior to the 8th of July, then it follows that Mr. Mulunga was never induced by fraud when he offered to buy Enercon's asset.
Just for
Lawyers will know that immediately I'm making sense and you are not making sense.
Just repeat your question.
Look, say you said you have done police training. Fraud is about making a misrepresentation.
I know the definition of fraud.
And let me just assist you. The misrepresentation must be made with an intention for somebody to do something at his or her prejudice.
That's correct.
In other words, the misrepresentation must occur first before somebody does act at his or her prejudice. Do you agree with me?
I agree with you.
You can't have a misrepresentation after the person has acted at his or her prejudice. You agree with me?
I agree.
Okay, let's then start. I have already fixed you to a particular day, that is 15 July. You said that is the day my client made a misrepresentation to Mr. Mulunga. That's what you said. You are bound by that evidence under oath. You said that.
Your Worship, I confirm that was the date when the asset purchase agreement was signed by Mr. Malakia and Peter Elindi.
Yes, but you...
And that is where the misrepresentation happened.
Yes. That's correct. I'm trying now to poke holes all over your case. Look, but Mr. Mulunga already acted on the 8th when he offered. He even fixed the amount himself on behalf of Namcor. Is that correct?
That's correct.
If the misrepresentation was later on the 15th, there was no act to induce him in fraud when he authored a letter on the 8th of July. Do you understand?
Your Worship, remember the charges when we started saying, I said there might be preliminary charges.
Are you now casting doubt on it? You're abandoning it?
I'm not casting doubt, Your Worship. Even when I testified during the examination in chief,
yes,
I was very specific of the offer, the commercial offer that was made on the 8th, and the agreement having been signed on the 15th.
But now when I ask you, and now you are trying to say, why are you telling me that they are preliminary? You appear to be telling me we were given half-cooked charges.
That's not what I'm saying.
Okay, so but you answered my questions then. And my clients are facing serious charges. You people have been leaking information to the newspapers. I will come and deal with that.
Your Worship, I don't know whether that statement was necessary that we have been leaking.
I will come and put it to you. No, I will stand by it. Okay. But all I'm trying to say is, sir, when Mr. Mulunga, on behalf of, I'm not saying he did something wrong, made an offer, he was not induced by a fraudulent misrepresentation by Peter Elindi and Malakia Elindi. It's very clear from your own evidence.
Yes, but they could also have said no.
No. Let's first agree. There was no fraudulent misrepresentation before the 8th of July, on your own version.
That's correct.
So it's not Peter Elindi and Malakia Elindi who instigated Namcor, who induced Namcor, or to use brute language, seduced them to offer to buy the title, right, and interest in those assets. Your
Worship, as much as Mr. Namanje, you are talking about the title and rights. And this is why we are here, because Namcor or Mr. Mulunga had offered to purchase the fuel storage facility. At that point, they should have said, no, we can't sell this to you.
That's not what I'm asking. I will come to that. You continue running away from the real question. Okay, fine. Okay, then on the 8th, then we know that on the 15th of July, my client signed the contract, written contract. Is that correct?
That's correct.
On that day, was the agreement concluded in law or not?
The agreement was only concluded on the 18th after it was signed by Mr. Mulunga.
By Mr. Mulunga?
That's correct.
Okay. Now, remember, I asked you, which comes first? Is it an offer or an acceptance? You remember I asked that?
Yes.
And you said?
The offer was first.
And in generally, the offer
Generally,
must
the
always
offer
be.
is first.
You cannot accept something that does not exist.
Yes, but you can also, yes, you cannot accept also something that you cannot offer.
No. I'm not talking about that. Just listen to the questions, please. Okay? Let's go on. Now, who drafted the agreement?
Namcor Trading, or Namcor itself.
Do you know about a principle that if the agreement is ambiguous and there is something that is not clear, then the law uses it. It will be used against the party that drafted the agreement. Do you know about that principle?
No, Your Worship.
You don't know. When you were investigating, you didn't come across such a principle because it will be very relevant, that principle, in this matter. You don't know.
Your Worship, I answered already.
Okay, can you go to the white bundle that we hand up Your Lordship today, Your Worship today? Yes, the law of contract lecturer is already stating it. Page 160. That is a judgment of Mbabus versus Motor Vehicle Accident Fund 2016, Volume 3, NR 605, authored by Deputy Chief Justice Damaseb. I want you to read paragraph 52. No, let's start with paragraph 53. Read it out, please. At page 160.
Yes, I'm there.
Yes, can you read 52?
Although he does not, you said 53?
No.
You said
Yeah, no, 53, yes.
Although he does not assign any legal label thereto, in my view, Mr. Namanje, Mr. Namanje's submission raised against the fund two important principles of our law.
I think just read for context. Read. In my view, Mr. Namanje's submissions raised against the fund two important. Continue.
Yes, two important principles of our law. Contra preferentem and
Yes.
declaration against own interest, or combination of the two.
Yes, go to 55, 54.
54. As Christie aptly remarks, the preference is the party to the contract who, whether personally or through his agent, is the author of the wording of the contract, and the rationale of the contract preferentem
Yes.
rule is simply that if that wording is incurably ambiguous, its author should be the one to suffer because he had it in his power to make
His
his meaning
plain.
plain.
Okay, So it's common cause. The agreement was drafted by Namcor legal team. Did your investigation find that?
Yes.
Okay. They are the one, so Namcor and its agent are the author of the agreement, not Enercon.
That's right.
Every terms, every ambiguity, if any, as we will continue, they are the author.
They are the author.
On the basis of that principle, if there is anything unambiguous, it works against Namcor, not against Enercon and its directors.
As far as the civil process is concerned,
No.
Yes.
It's fine. You are in a danger. You appear not to know the things, but that's all what I'm trying to say.
Of
Whatever it's authored by Namcor.
yes, that's what you are saying.
Okay. Let me then.
It's an objection. I have to state that from the onset, I think we have been dealing with the law of contract, and I think it has been said. In fact, I have been criticized that what is the relevance. So for me, I do not see any relevance to bombard this witness with questions that relate to the law of contract and refer him to cases. That is not for him to interrogate or to interpret. I think he has already indicated that he did not study the law. And to expect him and to confine him to questions that relate to the law of contract, I think it's very unfair. These issues that we are bogged down with, these are issues that can be argued on a later stage. I do not know how long Mr. Namanje wants to labor on this issue, but I do not think they are relevant to the current issue as we are dealing with the issues of bail.
With the greatest respect to your worship, in fact, not even relevant, but highly relevant. And I did not ask the witness to give opinions. I said, where you do not know, I will assist you so that you understand. It's very relevant, your worship. May I proceed, your worship? I want to move to another aspect.
Do you want to move to another aspect?
Yes.
Okay, then you can move to the other aspect.
Yes. There's something strange with. Did you read these charges? Did you read them?
Your Worship.
Yesterday you said you read them.
Your Worship, yesterday I was asking for the charges. That's why I wanted to go through this charge. So if you ask me about the charge, and I wanted to go through the charge so that before providing any answers.
No. When are you saying you have never seen these charges in your preparation for this bail application?
Your Worship, can we proceed to the next question? Then
No. Your worship, can the witness?
So the question was, did you read the charges? Did you read them or you did not read them?
Yes, Your Worship. During the time when the state was preparing, I was there. I looked at them, but I know they were revised at some point.
So, when you read them, you were happy with the charges, as they are
I'm
framed.
still happy with the charges.
Okay. Let me give you an example that is troubling me before I start with the new aspect. If the court bundle D2, and I want to ask the witness in relation to the charges relating to accused number 4 in the bail application. Dunaiski is applicant number 6. We have the charges. Her charges start at page 12. Yes.
Her charges.
Yes.
But you are referring to her charges.
Yes.
Why her charges, not your client's charges? If I understand. You are saying, you are referring to the
Yes. I said yes because the charge relates. There is something about my client in there.
Yes, that is what I'm asking. Why her charges? But yes. that is-
Okay, may
At what page?
12.
Namanja, which bundle?
Okay, it's
Which bundle?
D2, the one with the charges. Yeah, Your Worship, rather, can I start at page 13, count 32?
Yes, as you please.
Yes. Now, can you read that charge, count 32? Read it in the record. Is there, just to be fair to you, is one of the charges against Ms. Olivia Dunaiski. Can you read it for the record?
Count 32, fraud, in that during the period of 8 July 2022 to 4 May 2023, at or near Windhoek, in the district of Windhoek, the said accused did wrongfully, unlawfully, falsely, and with intent to defraud, give out and pretend to Enercon Namibia Pty.
Okay,
Ltd.
just end there for now. So that charge of fraud, it's fraud being committed by Dunaiski against Enercon. Enercon is the victim. That means that according to, because you give out and pretend to Enercon. If you don't agree with me,
No, I
read, complete the whole chart.
Okay, to
Continue.
Enercon Pty Ltd that as an employee of Namcor, to wit, commercial manager, she had the board approval to purchase 9 service stations from Enercon Namibia and therefore caused Namcor to suffer an actual loss of 53,212,000, whereas in truth and in fact the accused, when she so pretended, did not have the board approval, therefore the accused did commit the crime of fraud.
Mr. Inambao, if you honestly, as a senior investigating officer who have worked for Namibian police, already you would have picked up serious problem with these charges in 3 respects. Can you pick out 1 or 2? If not, I will assist you. Serious problems.
Mr. Ramanje, you have already picked up 1.
You
Pretended to Enercon.
Yes.
And, you know, Your Worship, if you allow me, I believe when these charges were being prepared, this was the time when Mr. Advocate Lungwe was actually just coming out from sick leave.
What do you mean now?
No, what I'm trying to say is the amount of time that the state was given to come up with all these charges at that very time, it was probably just done over Saturday. And I know Mr. Namanje and the other council were actually complaining about the turnaround times. When will we be receiving the annexures and so forth?
But
and so
why
on.
did you not assist him? You said you read the charge. So now you are saying the state did not have enough time, they did a bad job because there was no time. Why did you not assist him when you read the charge?
I did.
Did you speak to him?
What I'm trying to say, Mr. Namanje, there was a lot of things going on. But it doesn't mean that there is no offense. So if it was a misplacement of a word, that could have happened given the amount of time that is.
But do you know that you are bound in a bail application to the charges you gave? This is the charges my client came to court and showed that the state case is weak. It is on these charges the court will be working. Do you know that?
That's
yes,
right.
they are.
That's right.
So, but I think you are trying to run away again. But you agree with me, this is, in fact, this charge does not make sense to the extent that it appears as if it is not even on the charge sheet. It's a useless charge. The victim is Enercon. The prejudice is to the victim of fraud is on Enercon, while the prejudice is to someone else. What kind of law is this? Very bad. Mr. Inamba, why did you rush to arrest people when you are not ready? Why?
Why did I rush to arrest people?
Yes,
Your Worship.
and put my colleague under pressure for the state. Your house was not in order and is still not in
Can
order.
you just allow him an opportunity to comment? You asked the question, why did you rush to arrest people? He was about to respond and you proceeded.
Your Worship, the investigations was at an advanced stage. So as to whether the prosecution had sufficient time to properly put charges, Your Worship, that is something within the prosecution. As far as from the investigations is concerned, Your Worship, it is out of place to say that the investigations was not ready, Your Worship.
But the problem you have is not the public prosecutor who goes in the witness box. It is you under oath who was telling us and all and sundry today that this case is strong. You
Yes.
can't go to prosecution war with such kind of charges.
Your Worship, there are preliminary charges.
So something else is coming, not these charges. So they are preliminary.
The duty to provide for the charges as per the charge sheet, Your Worship, is for the prosecution.
Okay, let me make it difficult for you again. Now, let's go to, bring it closer home to my clients. Go to page 14.
Page
14.
40
One
or
four.
14.
Yes. And I want to take you right to the to count 45. You see count no 37 at page 15 your you see that count starting at page 15 at the bottom.
That's right.
Now over the page, can you read it out?
Count 37, contravening section 45, subsection 1, subsection B, read with section 32 and 49 of the Anti-Corruption Act, 2003, Act 8 of 2003, dealing, using, holding, receiving, or concealing gratification in relation to any offense. In that is now page 16. In that during July 2022, at or near Windhoek, in the district of Windhoek, the accused did directly or indirectly, whether on behalf of himself or on behalf of any other person and or entity, to wit, Enercon Namibia Pty Ltd, received an amount of 53,212,000 Namibian dollars, which was obtained as gratification or proceeds of fraud or money laundering.
Okay, let me just ask you one question before I then demonstrate again that honestly you could have done better. But let me first make, you see the word or between gratification or proceeds. Do you see that usage of the word or?
Okay, give me.
The same thing you read now, after 53 million, it says which was obtained as gratification, you see that?
Yes.
Or proceed. So it's a choice, which one? You are the investigating officer. Is it gratification or proceed? Or you don't know?
Your Worship, I would say both.
No, why did you not use and? It can never be both. It can never be both.
Your Worship, is what is on the paper.
Yes, I know
Yes.
it is what is on paper, bad as it is.
Your Worship, but it can also be one way or another. But in this regards, it can be both.
Okay, so you are not sure?
Your Worship, the 53 million was proceeds.
Okay, So you are sure it's proceeds?
At the same time, it was a gratification.
Okay. Let me make it. And this charge is in terms of Section 45 of the Anti-Corruption Act. Go back to page 15. It's referred to
Yes.
45.
45.
Go to page 60. You see that section 45. You see that?
Just say, are you there?
I'm there, Your Worship.
Page 60.
Yeah, can you
Yes.
read 45? I will say stop. Can you read it? I will say stop. Section 45, can you read it please? At page 60.
Page 60.
Yes?
Yes, you were earlier informed to go to page 15, but then he indicated go to page 60.
Okay, not 16.
No.
60.
60.
I'm there, page
Yes.
60.
Read 45.
A person commits an offense who directly or indirectly, whether on behalf of himself or herself or on behalf of any other person,
Okay. Read
A.
B because your charge referred to B. Only read B.
B, uses or causes to be used or receives, holds, controls, or conceals any property or any part thereof,
Continue. Which was?
which was obtained as gratification or derived from the proceeds of any gratification obtained in the omission of an offense under this chapter.
Okay. Now let's go back to page 16. The two offenses that are mentioned at page, your worship, page 16, line 4, are fraud and money laundering. You see that?
I see that.
But those are not charges under chapter 4 of Anti-Corruption Act.
Yes, they are not under the chapter 4.
Do you have the right to amend laws through charges?
Your Worship, I don't have the right to amend laws.
Why are my clients charged with something that is not possible as far as the Anti-Corruption Commission is concerned? Do you know why?
Your Worship, I cannot say why this is the case, but
This is wrong, and you must accept it if you are unbiased. It's wrong.
I'm saying, Your Worship, it's probably an omission because of the amount of pressure that the prosecution team had to deal.
Who is to blame for this pressure? You appear to be blaming my clients. If there is pressure, who is to blame?
No, I'm not blaming your clients.
Who are you blaming?
I am not blaming anyone. I am saying at the time, I remember because Advocate Lilongwe came, from sick leave, and he had to sit through the night to make sure that these charges were done. Anyone can make a mistake.
So now you call a mistake a strong case. You called this morning these wrong things, you called them a strong case.
In terms of the evidence that we have gathered, we have very good evidence which amounts to a strong case.
But for you to have evidence, you need, in the first place, there must be charges, proper charges.
I'm sure the state will still, correct this as they are preparing their indictments.
When
Your
are they
Worship.
going to correct?
As they are preparing their indictments.
No, but that is later.
Of course,
This
that's
is in the
later.
bail application with wrong charges.
Yes, and I believe I've answered your question
Okay.
because these offences are not under Chapter 4, and that is that was just an error that was made.
It's not acceptable, and I will demonstrate further. Your Worship, can we have a coffee? What time? Yeah, can we have 10 minutes? Yeah. It's cold so that I can just get coffee. 10 minutes.
10 minutes.
Yes.
Tea break. Yeah, we can maybe 10, 20, just
10, Your Worship.
10. Let's see. The code then. takes a break. Manje,
That's the court, please. Sir. Now, Mr. Inambao, now that I have laid the basis, let us now start with the actual cross-examination. I want to be brief and direct. Please listen to the questions, only answer my questions. You understand?
I understand, and I'll answer it to the best of my ability.
Yeah.
So if I have to expand, and you must just agree that I must be allowed to expand as well.
I will monitor you. What I'm saying, just listen to
Yes.
the questions. Now, I want to put this proposition to you as a former police officer and authorized officer at ACC. You have considered that there are a number of ways to secure attendance of an accused person to court. A number of ways, not arrest alone. At the beginning of my cross-examination, we dealt with that. You remember?
Right.
And when you say to secure attendance, do you agree with me? It's primarily for purposes of a trial.
Of course.
But, of course, if the consideration of justice dictate, it is only then a person can be prematurely be brought to court when the trial date is not within a short period of time. Do I need to repeat?
I hear you, but I don't agree with you.
Okay? So you understand the
Because
way.
the moment you secure the attendance of the accused person, it means, their legal representation comes in, investigation has to be concluded and so forth and so on. So there's a number of factors. But ultimately, is to ensure that the person, stands trial.
You don't understand. It's very clear. Look, people can come to a criminal court for purposes of a trial. Is that correct?
Not entirely correct.
For
You
what
are
other
not
reason?
going to secure the attendance of the accused person directly for trial.
Listen, the end object is for a person to stand trial.
And that's what I said.
Okay, fine. But it's only if there are grounds to arrest, to bring a person to court prematurely, when you are not ready, can you arrest a person to come to court? Do you agree with me?
I don't think I'm hearing your question.
I can repeat.
Please do.
If the end object of getting a person accused to come to court, the ratio behind it, it's a trial, and I mean a trial, then it must follow that in cases like in this case, where you are not ready for trial, it's premature, there must be a reason that triggered a premature summoning or arresting of a person to come to court before the trial date is set, the indictment is not there, the charges are half cooked, whatever. There must be a reason for you to prematurely. It's not just a nice thing to have.
I don't agree with your statement, Mr. Namanje.
Okay.
A lot of work has been put in terms of the investigations and the evidence that has been gathered.
Okay.
So for you to say that the trial date should be, just closed, that is not accurate.
Okay, fine. So otherwise, then it must follow your logic is this. If there is good evidence, even if you're not done, if you want, you can just arrest. The next day you ask for a postponement for further investigation. Is that the way you work?
Your Worship, investigations has been conducted for at least over 12 months.
Yes.
A lot of evidence has been gathered, evidence which proves that there were offenses that were committed.
Okay.
In this regards, the accused persons were brought to court.
But the state is not ready to have them going on trial. The state is not ready.
Your Worship, Mr. Namanje earlier asked me if I was talking on behalf of the state. And I think since he started with the cross-examination, he's been asking me to talk on the state and on the state. But as far as the investigations is concerned, Mr. Namanje, a lot of work has been put.
Your Worship, can the witness please direct it to answer the question? The witness did not answer. And I do not really appreciate a witness trying to argue. The witness didn't answer the question. Your case that you are investigating is not ready for trial.
It's still under investigations, but the investigations are at an advanced stage.
Yes, that's what I'm saying. But you arrested accused persons on the 8th of July when you do not even know when the trial will start because your investigation is not complete.
Your Worship, is not in my position to know, and I'll not be able to tell as to when the trial would be, because there's a number of factors that has to take place or to come in play before the trial happens.
Okay, but you did not cause my client to be arrested in January. You waited for July. Is that correct?
I don't understand what you are implying.
Yeah.
Because I know they were arrested in July.
Okay, let me make it clear. So it's a matter of choice when you want to do it. It's not dictated by the need to bring them to trial. It's just that because you have the power, you can exercise them anyway. You could have delayed it for 3 days. Nothing would have happened to the administration of justice. That's what I'm trying to say. You have these massive powers. There is no trigger event. You just wanted your hands to be laid over my clients and bring them to court, even when you have this wrong and bad charges. That's what I'm trying to say. It's not triggered by a particular...
Yes, Counsel, can you just make your questions short?
Okay.
So that he can answer.
Okay, look.
Yes, it's not triggered by any, if...
That is not accurate, Your Worship.
Okay.
There is a process that is being followed. Investigations was ensured, evidence was collected.
Yes.
By January, the month that you are referring to, maybe by that time the investigation was not at the level where it is currently is.
Okay. But tell us, what triggered in July that the accused person indiscriminately must be arrested? What triggered? Why could you not, for instance, wait until today? What triggered the arrest?
But Your Worship, he will still ask me the same question, why I arrest them today. I said already, evidence was collected, evidence was gathered.
Okay. Should I record it? Your answer, the trigger event, the evidence was collected.
What I said earlier is, the investigations are at advanced stage, and therefore the accused person's attendance was secured so that they can be brought to court, Your Worship. We finalize the few outstanding issues here and there.
Okay, so you were monitoring. If you have evidence up to this level, you would just then exercise your power to arrest. That's a trigger event. You were waiting for evidence to reach a certain stage. You are not ready for trial. Investigation is not complete. Then you arrest.
Your Worship, you cannot arrest a person on an investigation of this magnitude when you have one statement, because you will be shooting yourself in the foot in terms of the work. We needed to make sure that the level of work that has been put in place at least justify and proves that there are offenses that were committed.
Okay. I don't know whether you get it. Your answers are actually dangerous to your case, but I will ask in relation to another aspect. So, fine, you say you collected evidence, you cannot arrest if there is one statement. You waited until you have how many statements?
Your Worship, this is a significant investigation. I would not be able to tell the court how many statements we have.
Okay.
But I know when the prosecution was dealing with the charges, they had to go through over 20 volumes. And in total, Your Worship, we have at least over 40 volumes of evidence that we have gathered.
No, it's fine. Please remember that people cannot be arrested on arbitrary basis. Your action must be rational. You understand? Do you know that?
Of course.
The arrest must be necessary. Do you know that?
Of course.
Okay. Let's go over in respect of another aspect. You cannot name, initially you said it was, you cannot arrest on one statement. Now you cannot say how many statements. But was it you who took a decision that they must be arrested? Was it you?
Your Worship, I don't see the relevance of this question, because I work for the Anti-Corruption Commission. When a decision is made by the commission, not by me. I'm the investigating officer. It means we have processes in place that we put in place as to how investigations are conducted.
Oh. You didn't want to answer the question because it's not relevant, but you ended up disclosing that it's not you who decided that people must be arrested, including my clients. Do I get you correctly?
No.
So what is the no to? To that I didn't get you correctly, or not to what?
You didn't get me correctly.
Okay, what is your answer?
What I was explaining from the beginning is,
Yes.
we investigate. Once we get to a certain point, to a certain point,
Yes.
and have proven that there is sufficient evidence in these regards.
Yes.
That is why the accused persons were secured to come to court. Because there is, and as a commission, we believe the evidence that we have gathered, it's good.
Okay.
And yes.
Do you have a rigid policy that if you have a good evidence, you arrest before you transfer to the PG in terms of Section 31? Do you have a rigid policy that if the evidence is good, arrest? Do you have such a policy?
Your Worship, transferring a case to the PG can be done before or after an arrest. It just depends on a particular investigations.
Answer the question, sir. Do you have a rigid policy? If you have good evidence, you must arrest. Answer the question.
No.
Okay. So in some cases, you can have good cases, but you don't arrest until the PG decides. Is that correct? In some cases, you can have good evidence, you don't arrest until the state is ready with an indictment in its hands. Investigation is concluded, indictment is there, everybody ready for trial.
Each case, Your Worship, is dealt on its own merits, and it's also dependent on the seriousness of the case that is being investigated and the complexities that are involved. Your Worship, also taking into consideration of interference with investigations and so forth and so on.
Yes,
So there's a number of factors that are taken into consideration.
But in this matter, I have been asking you, your reason was not a fear of interference by my client. I have been asking you. Now, why are you talking about interference in general?
Your client is not the only person that is before the court.
Okay, fine. Okay. So, but let me make it clear. So, can I record it for purposes of my argument then? The sole reason why on the 8th, my clients of July were arrested is because a stage has been reached where you have what you call a good case. That's the sole basis.
Your Worship,
Based on what you told the court.
an arrest is part of investigation processes.
Okay. It's shocking. Okay, now, let me take it further. But did you consider how illogical your approach is? In that the next day, the first day of appearance, The public prosecutor, at your request, asked that the state is not ready for trial, the matter must be postponed for further investigation.
And Your Worship, I've said it before that the matter is still under investigations.
Okay.
There was no point when I said investigations is completed or
Yeah,
are
no.
completed.
I never said that. Or I'm showing how illogic your policy or your action. You go and collect people from their houses. There is no trigger event relating to interference or running away. It's just a good case. You, without exercising a discretion, you arrest. You fill up the court roll. That's why you people are under pressure, unnecessarily.
I'm not sure I
Yes.
can comment on that one, Mr. Namani.
If you don't want to comment, it's fine.
Because there's no way that it was illogical, the decision that we
Okay.
took. We took a logical decision, a decision that was informed by the amount of evidence that the commission has gathered.
But you made a fatal statement that will work against your case. You are not the one who decided to arrest. You said that. Who was that?
I said-
Name the person.
I said the commission.
No. Commission does not speak. Say the person. Commission, if it is a director general, you must say. If it is a deputy director general, you must say. If it's the chief of investigation and prosecution, you must say.
No, Mr. Ramanje, I don't have the answer for you. All I'm saying is investigations was at an advanced stage and a decision was made because of a number of other factors.
But then it is very clear. If that person, unknown person, didn't arrest my client, you wouldn't have arrested because it's not your decision.
I'm not sure of the unknown person that you are talking about.
We won't know because you don't want to disclose the person.
No, Mr. Namanje, investigations have been conducted. It has reached an advanced stage, and at that point in time, a decision has been made in order for us to make sure that all the other outstanding issues are finalized.
Do you know, I think you appear to, do you know that this is a country of a rule of law?
I'm very much
That
aware
you
of
must
that.
only exercise the power that you have. Don't exercise the powers you do not have. Do you know about that?
I'm very much aware of that.
Do you also know that you can only arrest a person if you yourself, the mental part of it, is satisfied that there is reasonable suspicion, the arrest is necessary, so someone must account for the arrest.
And I'm standing here.
But
I'm
you
the
are not-
investigating officer.
You didn't take the decision.
No, Mr. Ramanje.
What is no, Mr. Namani?
When I'm saying the investigations has reached an advanced stage, it means it has. And one of the investigation process is to secure the attendance of the accused persons to court. And that's what we have done. As far as exercising our powers, we made sure we exercised our powers within the rights. We exercised our work within the rights that we are also given.
Say, why is it difficult to tell the truth? What I'm saying, I thought you said earlier you did not make a decision. Now you are saying no, Mr. Namanje.
When I stand here,
Yes,
I represent the commission.
yes,
So, and when I'm saying we have a process within the commission that is followed,
yes.
so it means I'll stand by for it.
Okay, let me ask you a question. Is there shame to disclose transparently who made the decision to arrest? Is there any shame?
If you have a name of somebody that you think has made that decision, Mr. Namanje, maybe you can help me.
Your worship, can we get the witness directed to?
Yes, just answer, but the question, Mr. Namanje, has been asked. The witness is saying the commission made the decision. You want an answer, but he is saying the commission made the decision
Your worship,
and
I
he is not.
asked a different question altogether.
And Your Worship, I have to object because I think for the past 5 minutes the question has been asked and answered just a bit different. He wants a name and he has said the commission took a decision. The commission, not him. So I don't know if he wants a name, but he has answered. He has said that the commission took a decision.
Greatest, Your Worship, what the last question was, is there shame in disclosure? I'm now asking the ratio, the reason for not disclosing. I'm no more asking the name. The witness must answer the question, Your Worship. It's a country of, an arresting officer is the first time in my brief but active and
Mr.
busy.
Ramanje, you have put your question. Just brief question. Say, is there shame? What is your comment?
There is no shame, Your Worship, and I've answered it already. And I said I am here, and I represent the commission.
But I think you are contradicting. When you say you are here, but you are not the person who took the decision. You continue saying, when I ask another question, you say, I'm here. What does that mean?
Mr. Ramanje, I believe I've answered your question.
No, listen to me. Fine, I have asked about shame. Is it privileged to disclose who is an arresting or a person who took a decision?
You know, when I said the commission,
Yes.
it means there are different levels of structures.
Yes.
And when a case is being investigated, it goes through these different levels of structures.
Yes.
And hence I said, at a point, once we have reached a certain point in the investigations,
Yes.
then a decision is made for us to secure the attendance of the accused persons to court.
Yes, but it's fine. I'm asking this question for two reasons. One is on your credibility as a witness. One, in respect of an issue, the issue of necessity of arrest, because you cannot account for it because you are not the decision maker.
Mr. Ramanje, I have been in charge of the investigations.
Okay.
And I've indicated that investigations are at advanced stages, and at that point, a decision was made to arrest.
Okay. You did not arrest my client because you had information that my two clients, they wanted to run away. That's not the reason. That's not the reason. Whoever decided.
A number of factors contributed to that.
No.
But I did mention that we reached a certain point where we had overwhelming evidence, as I indicated in the examination in chief.
Your Worship, honestly, we cannot go on like this. If my clients were also asked by court and directed to answer simple questions, can this witness just stick to the questions I'm asking? Continue going back to we reached the certain stage. I want to be specific, Your Worship. The witness must just answer questions.
Sir, what is your answer?
Your Worship, is because the same question is being asked just in a different way.
The witness is protesting against court. Can the court direct the witness, please?
So what is your answer? Are you saying you have answered the question, or what are you saying?
I believe I've answered the question. Maybe he can rephrase the question, Your Worship.
Yeah, just be serious. We are not playing here, sir. Look, I'm putting it to you. You did not arrest my two clients because you have information they wanted to run away from Namibia. I'm putting it to you.
No.
Okay? I'm putting it to you. You did not arrest my client because you had information that they will interfere with investigation.
No.
Say, you did not arrest my client because they will be danger to the society if not arrested until you complete your investigation.
No, Your Worship.
Now I wonder why. Okay, let's go to another issue. Do you know that, I would assist you, do you know that even when you have a warrant of arrest, you have a discretion not to arrest? Do you know that? Have you ever read judgment saying that?
Yes, the discretion is there.
That even if you have a warrant of arrest from a magistrate, you can still exercise a discretion not to arrest because it's not necessary.
That's correct.
Okay. Do you know the requirement both in the Criminal Procedure Act and in the Constitution that a person being arrested must be promptly and fully informed of the grounds of his arrest. Do you know that?
That's right.
In relation to this matter, did you comply with such obligations at the time of arrest?
Most definitely.
Okay. So, I understand you that in relation to the grounds of arrest appearing in the purported warrant, you fully and promptly informed my clients.
That's correct.
Do you agree with me that if you do not understand the elements of a particular offense, then there is no way you would have fully and promptly informed a suspect? If you don't understand as a police officer or a member of ACC, you don't understand the elements of the offense, it will be difficult, in fact, impossible for you to explain meaningfully to an accused person.
When a person doesn't understand the charges, that might be the case, Your Worship. But in this regards, we made sure that the charges which were on the warrants, we understand the elements of those charges.
Okay, no. I want to take you to the charge and demonstrate that, in fact, you don't understand, Mr. Inambao.
Sure.
Okay. Now, and that is what I'm going to do.
Maybe before you proceed, it's opportune time for the court to take a lunch break.
That's the court, please.
Yes. The court adjourns until 1400 hours.